You know what, I'll shift my chair over and you just pull your chair. We'll just do that. Yeah.
back on the record outside the presence of the jury. Are we ready to bring the jury back in? Okay, we're ready.
Everyone, please rise to the jury. Please remain standing, please.
Welcome back. Everybody can be seated. Thank you. Did the jury follow the admonition? Yes, sir. Thank you very much. Final arguments on behalf of the company.
Ladies and gentlemen of the jury, on May 10th, 2011, Josh Young murdered Trey Zucker in one of the most brutal crimes imaginable. He beat him to death as Trey suffocated on the mud that his face was pounded into, while the baseball bat hit the back of his head. In the creek by Liberty High School, right behind the house where he lived with his mother and his sister. Did the defendant do this alone? Did he do it with Josh Gowker? Did he hit the back of Trey's head with a baseball bat while Gowker used a metal pipe? Did Young use a baseball bat and a metal pipe? Before we get to what happened, I'm going to go over the jury instructions so you know what I have to prove. You have to believe beyond a reasonable doubt that in Jefferson County, Kentucky, on May 10th or 11th, 2011, acting alone or in complicity with another, Josh Young murdered Trey Zucker, and that he did so intentionally. May 10th or 11th, Jefferson County, everybody testified to those two elements. Acting alone or in complicity with another. That other is obviously Gowker. But what does complicity mean? A person is guilty of an offense committed by another person when, with the intention that the crime happens, he, among other things, aids or attempts to aid such person in planning or committing the offense. That means that if you believe beyond a reasonable doubt that the defendant helped his dad plan or commit this offense, and that when he was doing so, it was his intention that the murder occurred.
Come up.
And now, you have the proper instruction in your copy of the jury instruction. It's the proper definition of complicity. And so turn to that page and you can see sorry, my slide, there was an error. With the intention of promoting or facilitating the commission of the offense, he solicits, commands, or engages in a conspiracy to commit the offense, or aids, counsels, or attempts to aid such person in planning or committing the offense. That means that if you believe beyond a reasonable doubt that the defendant helped Galper plan or commit this offense, and that when he was doing so, it was his intention that the murder occur, then he is as guilty as his dad. That is the law in Kentucky. And you will notice that under the murder instruction, it says alone or in complicity with another. To find him guilty of murder, you have to believe that he was acting alone, or you have to believe that he was acting in complicity with Galper. Either scenario results in a murder conviction. Some of you can believe he was acting alone, and some of you can believe he was acting with Galper. But as long as all 12 of you believe that he committed this murder under either scenario, you are unanimous. And that makes sense. It would be ridiculous if some of you believed that he committed the murder standing by himself, and some of you believed he committed the murder standing by Galper, but you couldn't agree as to the scenario that he would then walk. As long as all of you believe beyond a reasonable doubt that he committed the murder one way or the other, alone or in complicity, you are unanimous as to guilt on murder. The other, next slide, please, thank you. The other charge is tampering with physical evidence. And you have to believe, beyond a reasonable doubt, that the defendant, on or about May 11th, concealed clothing and or a murder weapon, which he believed was about to be produced or used in a criminal proceeding, and that he did so with the intent to impair its availability. And the second part of that makes sense. Obviously, if somebody is throwing away clothes and a murder weapon immediately after a murder, they are doing so to keep it from the police. And obviously, we would have wanted to have used those items in the prosecution. So then we back up to the only question here, which is, did Josh Young do this? And before I get to applying the facts of the case to the elements, which is where I would normally go here, I first have to step back and discuss Galper and his plea. Because the unusual nature of this case leaves us with somebody who has pled guilty and said that he did this all by himself. And if you believe that, then obviously you can go home right now. But what Galper said in his plea in this courtroom was a bunch of lies. And this is why. He testified that after the cookout, he and Amanda went back and forth between her house and Cassie's, that they ended up fighting in the front yard in front of Cassie's. He gave her the bruises on her neck. They made up, had sex, needed cigarettes, went to the store, came home, had more sex, made a video, and that then he woke up and played video games on the couch with Trey. Apparently they said on Mackenzie. He said they played video games on the couch. He noticed that his food was gone. He saw Trey with his lighter. He got angry about the food and the lighter, and he went down to the creek, took Trey down to the creek, said they would smoke pot together. He wanted to scare him, and he ended up killing him. And that then he disposed of his clothes in a dumpster behind a Mexican restaurant. Although he told you in court that it was on the way to McNeely Lake. And that is a lie. First of all, let's start with the lighter. This is the lighter found in Trey's pocket. It is a gas station Bic lighter. It is not a lighter that even Josh Galper would kill somebody over. Mackenzie slept on the couch. Galper testified that she wasn't on the couch. Mackenzie testified that she was on the couch.